proceedings has always been the case. And that was so before tort reform. And so if a judge felt so inclined upon a party's request, they could have a trial on damages. They could have a separate bifurcated trial on fault. They could have a separate bifurcated trial on liability. And that's important because these are distinct concepts. Liability is a distinct concept from damages, and liability and damages are distinct concepts from fault. One thing that I think is problematic about 51-12-15 is that it talks about phase one, but only uses the legal term of art of fault. It doesn't use liability. I think it would have been cleaner and easier to understand if it had said, in the first phase, the trier of fact shall consider liability and then fault and the apportionment thereof, or something to that effect, to recognize the distinction between the two. Because, Judge, liability is, of course, a distinct legal question. Did the defendant owe the plaintiff a duty of care? Did the defendant breach that duty? Did the breach of that duty proximately cause the injury? And did the plaintiff sustain damages? That's the question of liability. In a non-default situation, the parties would be allowed to introduce evidence, and the jury could sort all this out if they wanted to. And of course, there can be or there could have been circumstances where the jury would have heard evidence about the plaintiff's damages and would have been considering that evidence alongside their consideration of liability, and in some cases, apportionment. And so I believe, I don't have the legislative history in front of me, Judge, but based on watching how the legislation went down last year, I believe some of the motivating factors or the rationale given for 51-12-15 was to put juries in a position where they could fairly and objectively evaluate liability and fault without receiving evidence of a plaintiff's damages, for the obvious reason. Sometimes a jury might hear evidence of a plaintiff's damages, feel sympathy for the plaintiff, want to compensate the plaintiff, etc. It might conceptually overlook or not fairly assess the fundamental question of liability. And my contention is that is at least one of the reasons why we now have 51-12-15. The point of 51-12-15, the legislative intendment of 51-12-15 is to let the jury objectively and fairly evaluate liability and apportionment of fault without consideration of damages. But before tort reform took effect, that was not the order of things when a default judgment came into the picture. And the principal case I cite for that is the Martin versus Six Flags case. This is a case, and I'm sure the court knows, where the defendants were placed in default, I believe because of a discovery violation, some kind of sanction. Their answer was stricken, and so the judge placed them in default. Briefly, Judge, there is no meaningful distinction between a defendant who is placed in default as a sanction for a discovery violation or a defendant who becomes in default because they don't answer. The effective default is the same. They have deemed the well-pled allegations of the complaint for the well-pled and valid claims and causes of action under Georgia law, and they are liable as a first question to the plaintiffs for damages. And explaining apportionment and how it applies in a default context, the Georgia Supreme Court said that once liability has been established by default, the damages sustained by the plaintiffs have been calculated. The trier of fact must then assess relative fault for all those who contributed to the plaintiff's injury, including the plaintiff himself, and apportion damages based on the assessment of relative fault. In other words, the jury has to take the total amount of damages sustained by the plaintiff and then identify the persons who are at fault and award damages according to each person's percentage of fault. Thus, once liability has been established, the calculation of total damages sustained by the plaintiffs is the first step, and the allocation of fault and award of those damages according to that allocation, is a distinct separate step. That was the state of the law, the jurisprudence interpreting the common law before tort reform took effect. So from my perspective, Judge, the very next thing that is supposed to happen after a default judgment is a trial on damages, because damages is a dollar amount. And I think it's important to say it that way. And that dollar amount is supposed to be based on evidence that is relevant to the damages itself. So in a car accident scenario, you might hear evidence of medical bills, lost wages, a plaintiff's testimony about their pain and suffering, loss of consortium, etc. In a wrongful death scenario, the measure of damages is the full value of the decedent's life, measured by economic factors, if there are any, such as job prospects, maybe intelligence, wages at the time of death, career, and so forth, but also the intangibles, the things that are non-economic, loss of companionship, loss of family, loss of the ability to live a life and have life experiences and so forth. Traditionally, that measure of damage is proved by testimony of family, friends, people who can give testimony about the person's hopes and dreams, aspirations, maybe their life expectancy, their health, family history, and so forth, to try to find some objective way to evaluate how long the person would have lived and what the damages for the intangibles were. That's a distinct evaluation that, in theory, should have nothing to do with who is going to pay that damage and what percent thereof. Apportionment of fault is only a question of relative responsibility for a total damage award. It's a percentages game. But the evidence of the apportionment is not permitted to reduce damages, because damages is a distinct concept based on different sets of proof. So in a car accident example, a fair evaluation of a plaintiff's medical bills, the reasonable value of those bills, their lost wages, their pain and suffering, is going to be based on a consideration of a different type and kind of evidence than a jury would consider if they are trying to figure out whether the defendant is 100% responsible for that amount of money or is less than 100% responsible. In support of that, Judge, I will direct the court's attention to one of the cases I cited in my latest pleading. This is Western and AR Company versus Jarrett, 22 Georgia Appeals 313 from 1918, so over 100 years old. This case explained this principle, but under the ambit of contributory negligence. It explained that the contributory negligence of the plaintiff is a defense that reduces damages rather than bars recovery. The court explained in that case that a plea setting up as a complete bar to any recovery and alleged want of ordinary care on the part of the deceased and of her husband is an entirely distinct and separate defense from the defense of comparative negligence, which authorizes a jury to diminish the recovery where the negligence of the plaintiff or the deceased did not amount to an entire lack of ordinary care. The court noted that the law in reference to contributory negligence in Georgia is generally used in the sense of negligence which will reduce damages rather than in the sense of negligence which will prevent recovery. So the point that is important to draw there is that damages is a distinct legal concept, that the evidence about damages, the evidence used to evaluate damages, has to be measured differently than the types of evidence used to evaluate apportionment. And so what do we do then about the new statute? Because it's clear from the Martin versus Six Flags case that the first and distinct step after a default is to have a trial on the amount of damages, what the dollar figure is. This is an important point to drive home, Judge, because just to be frank, what the plaintiff is concerned about here is that the defense under the guise of damages evidence and under the guise of an apportionment evidence or argument presentation, will present evidence to a jury before they ever get to consider damages that will inevitably and unwaveringly impact how they evaluate damages in a second phase, of course. And that concern is not without precedent. In the racetrack case, Judge, Taylor versus Racetrack Petroleum, 238 Georgia Appeals, 761, 1999, cert denied in 2000. This was a case where the court grappled with whether a jury could consider character evidence and other acts evidence and prior conduct evidence that the defense wanted to admit about the decedent to show effectively that he wouldn't have lived that long and his manner of living was reckless and such that he wouldn't live a long life, and even if he did, it wouldn't amount to much. I'm paraphrasing, but that's sort of the gist of it. The majority in that case disagreed with the defendant's argument and the trial court's ruling that evidence of the decedent's alleged drug and alcohol use on other occasions was relevant to the issue of damages because such use will affect his life expectancy. In some cases, a person's long-term drug and alcohol abuse may affect that life expectancy, but anecdotal evidence relied on by Racetrack was inadequate to prove the effect of drugs or alcohol on an 18-year-old decedent's potential earning capacity or his life expectancy. There was no expert witness about that in Racetrack, and that was one of the things that it considered. And it noted that the evidence, while perhaps showing that the decedent had engaged in such conduct as a matter of fact, it did not provide any indication as to whether the conduct was so fixed and uniform as to be habitual. And unlike habitual conduct, evidence of a party's character in performing certain acts is not admissible. And in this case, the court highlighted that even if it were relevant to the issue of damages, and it wasn't, the proper procedure to avoid prejudice to the plaintiff on the issue of liability is a separate trial on the issue of damages after a liability has been decided. So that re-emphasizes that damages and liability are distinct and that the evidence offered to reduce damages cannot be used to reduce liability because they're distinct concepts. In that case, also, the court held that that same evidence was likewise not admissible and may prejudice the jury against a party on the question of liability. So the court in Racetrack, the majority is holding that this type of evidence about the decedent, the dead person, is not relevant to prove damages and is also not relevant to prove liability or, in our context, apportionment. There was a concurring opinion in Racetrack, Judge, that further emphasizes the basis of the plaintiff's concern in this case. Judge Andrews concurred specially and said that while he disagreed with the majority on the relevance to damages, he agreed that the evidence could have prejudiced the jury's determination on the issue of liability. Therefore, he would hold that the trial court erred in not granting the plaintiff's motion to bifurcate the trial on issues of liability and damages. Now, apportionment was not discussed directly here, but the point that I'm driving at, Judge, is that this is an example from Racetrack where a reviewing court judge in a concurring opinion is recognizing the obvious, that in determining what evidence is admissible on the intangible value of decedent's life, typically affords those witnesses a wide latitude so that the jury may consider every fact and circumstance that would throw light on the value of his life. That's the damages question. And in this case, in the Racetrack case, the plaintiff introduced that kind of evidence, that the decedent was loving and friendly and had charisma and so forth. In that case, the trial court found that the plaintiff had opened the door to basically his bad character evidence, including evidence that the decedent was in a group of people which got together every day to figure out how they would get intoxicated. that they did a lot of acid, they drank beer, they smoked a lot of pot. That witness further testified in the racetrack case that the decedent engaged in risky behavior in general, driving on 5 hits of acid and smoking 2 blunts. The concurring opinion here noted that the majority focused on the relevance to damages. But he went on to say that, quote, there is always a danger that evidence admissible for one purpose but not for another will prejudice the jury in reaching its decision on that other issue. And this is such a case. Therefore, in cases of this type, the trial court must consider seriously the danger inherent in not bifurcating the trial as to liability and damages. Here, because the evidence concerning the decedent's drug use and drinking and driving was relevant in response to evidence produced by the plaintiff on the intangible aspects of the value of his life, and it was yet inherently prejudicial on the issue of liability, and the trial court erred for not bifurcating. So I cite that case, Judge, just to illustrate that evidence of apportionment, which the defendants have a right to introduce, if we're not careful, can impact or can invite or prejudice the jury's obligation to fairly and distinctly evaluate damages. And so if this was a non-default case, I would argue that they wouldn't be allowed to enter that in evidence on the liability phase. But liability's been established. They're in default. They've admitted the well-pled allegations. They are liable to Mrs. Madrigal for her son's death. And our contention is that they have admitted the well-pled allegation that he was lawfully on the premises as a lawful invitee, was shot and killed by unknown criminal assailants as a 15-year-old boy, and everything else alleged in our complaint. The law in Georgia states that they cannot introduce evidence that contradicts those admissions. But the plaintiff's fear is that in the effort to, quote unquote, apportion their percentage of fault, they will seek to introduce evidence that does that invites the jury to consider that Luis Perez, in this case, had gang affiliations, is seen in some Instagram photos of holding a pistol, maybe had some truancy problems at school, maybe was known to affiliate with people of disrepute and lived a reckless life. That's exactly the type of evidence that the Georgia Supreme Court has said is not admissible for either damages or liability. And so it shouldn't be admissible for apportionment either when the plaintiff is in a default position and cannot be considered to be at fault. So basically, Judge, I know I've been going a long time.
It's okay.
Our position is that the default stops the defendants from offering evidence that would essentially amount to a liability defense and call it damages evidence or apportionment evidence. They're stopped from doing that. They can't offer any evidence in any phase of the trial about what Luis was up to, why he was there, and whether he bore any percentage of fault or responsibility for his own death. They're stopped from doing that, and it's a consequence of the default. What they can do in an apportionment phase is introduce evidence about the criminal assailants and make arguments about how they should bear a percentage of fault. And I will concede that. They're the ones who have to come forth with admissible evidence that's admissible and under the rules of evidence to show that the shooters bear some responsibility in addition to them. And so because of how all this works, I think the wise thing to do is to construe the 51-12-15 statute as being a more broad and generalized procedural statute that must be construed alongside the more specific statutes of 9/11-55, default, and the apportionment statute, 51-12-43. If it does that, that would at least be a legal statutory construction reason that the court could hang its hat on, explaining to the Court of Appeals, this is why we did damages first. They're in default. They can't offer evidence to defeat liability. They can't offer evidence to defeat the right of recovery. There's all this case law that says the next first step is damages, and then apportionment comes after that. That's the common law. That's the jurisprudence. The apportionment or the new phase statute doesn't deal with this directly. And to avoid any risk to the plaintiff's right to have a trial on damages, apportionment is going to come second. I think that is a discretionary call that the court can make to protect the plaintiff's rights. As a final note, if the court is not inclined to do that, if the court is looking at the plain text of the new tort reform statute 51-12-15, where it says that in all cases, including this one, the trier of fact shall consider fault and apportionment of fault without consideration of damages, and taking that at face value for what it is and not wanting to get it wrong. I think the way that you have to fashion to control the evidence in this case is to, if you want apportionment to go first, Judge, is to allow the first phase of the trial to be on apportionment, but also order that the defendants are precluded from eliciting testimony or submitting evidence that tends to shift blame or fault or liability on Perez, the decedent, because that would contradict the well-pled allegations and their default. In order that any evidence that they tender on apportionment of fault be strictly limited to the non-party criminal assailants, which we would stipulate to. And we would stipulate that there should be on the verdict form a blank for the assailants, and that the court could instruct them on that. I think that would save the court and the jury a lot of time. Yes, we agree. Somebody else shot him. That's the base. That's the crux of a negligent security place or type of claim. And then they can make whatever arguments they want to based on the evidence. But I think that's the best way to go forward with it.
Random question.
Yes.
On the verdict form, in your mind, are Regency and Millennia on the same line, or are they on their own separate lines?
I think they're on the same line.
And I'll ask y'all the same question in just a minute.
That issue hasn't really come up.
I haven't seen much daylight between the two, but I just wanted to get that.
Well, the truth is, Judge, if the court were to find that my well-pled allegations in the complaint allege that they jointly owned and managed Ava Park, that would be a basis to hold them on one line in the verdict form. I also don't think the defendants are, and I'll let them speak for themselves, but I don't believe they are making a large argument there.
That's fine. I'm looking for your take on it. That's okay.
Yeah, I mean, Regency was a single purpose entity that held title to the real estate. After Luis was killed, the city of Griffin condemned it, and then they sold the property. So the LLC still exists, but there's no assets to it. And Millennia Housing Management is the property management arm of the Millennia companies. And so they're distinct LLCs. But I don't, that's what I'll say about it, Judge.
Right. And the extent of that question was just me having a moment and going, all right, and visualizing your version of that option to me on the verdict form, is that one line or two? So, okay.
Right. And I'll just add, Judge, I think the way that you could make that decision, keep them on one line, is just to find that they are deemed admitted to be jointly and separately liable based on the well-pled allegations of the complaint.
Okay.
And if they want to apportion fault between themselves, they're going to have to come forth with evidence to do that.
All
somehow.
right. Thank you. Anything else on this specific topic before I pivot?
No.
All right. Are you running point on this topic?
I'm running point on this one. I think Mr. Van Meter touched on, I think just by the very nature of this, much more than the bifurcation. And so some of those things I'll try to touch on now as part of that. I don't intend to going through all of them on the bifurcation piece, because I think the bifurcation piece is actually simpler than what Mr. Van Meter just described. And I'll lead by saying, I'll lead where he left off. Is if the court's going to look at the plain language of the new bifurcation statute and determine liability and apportionment in the first phase and damages in the second phase, then there should be limited instructions. I think the court should follow the plain language of the bifurcation statute. And we briefed this. I'm happy to answer any questions, but I'll walk through it. Starting with the statute. The statute itself says in the first phase of the trial that the trier of fact shall determine the fault of each defendant. And if the trier of fact finds that any defendant is at fault for the plaintiff's injuries or wrongful death, and I'll stop there, because at this point in 51-12-15, because we are defaulted defendants, fault has been found. And I recognize that the statute using fault and not liability in different places can be confusing. But this is something that has previously been brought up in view of the apportionment statute in KOS and the Zlativer case. Both talked about this distinction between fault and liability and apportionment. And I don't see how the use of the word fault versus liability would support flipping damages and apportionment, or apportionment and damages rather. So the first part of 51-12-15, once the fault of any defendant is determined, which has happened here because of the default. So that's liability for us, right? Then the trier of fact shall further determine through an appropriate form of the verdict the percentage of the fault of all persons or entities that contribute to such injuries or wrongful death, as provided in Code Section 51-12-33, which is the apportionment statute, obviously, prior to any determination of the total amount of damages to be awarded if any such findings are required. So, Your Honor, the defendant's position is that under the plain language of the statute, apportionment is what follows after a default. And there are exceptions to when the courts can apply the new apportionment statute. They're enumerated, and hadn't briefed this, but it's the familiar, the expression of one is the exclusion of another rule of statutory construction. So when they carve out two instances where courts are not required to honor a defendant's or a plaintiff's request for bifurcation, that being if it involves a sexual offense that would cause emotional distress to testify twice, or being less than $150,000. Those are the two exceptions to the rule here. There's not a default. There's not a default exception. And I think there's, and I might be making up a statutory rule of construction now, and I apologize if that's the case, but I think there's a statutory rule of construction that the legislature knows the lay of the land with respect to the precedent that exists at the time, which means they would be aware of the Martin case that we're discussing. So still within the plain language of the statute here. And so within the plain language of the statute, it provides the order in which bifurcation should occur, and it provides the only two instances where bifurcation will not be followed if it's requested by the plaintiff. As we talked about, as we came on the record, the effective date of the act is April 21st, 2025. And that statute says that it will apply unless the application would be unconstitutional. So now there is, I guess, potentially a third way in which bifurcation cannot be applied for cases that were pending at the time of its enactment. And that would be if it's unconstitutional. And when you get into the unconstitutionality, what you're talking about is whether or not it can apply retrospectively. And that determination is based on whether it is a procedural or a substantive change to the law. I think Mr. Van Meter, even in his argument, I don't want to misstate it, but I think he even acknowledged that the bifurcation statute is a procedural mechanism. And it does not affect the rights. It does not, in the language we cited in our brief, and this is from Fowler Properties, Inc. versus Dowland, which is 282 Georgia 76, which is a Georgia Supreme Court case citing Enger versus Irwin, 245 Georgia 753. The Georgia Supreme Court explained there that the distinction between a substantive law and a procedural one is that a substantive law creates rights, duties, and obligations, while a procedural law prescribes the methods of enforcing those rights, duties, and obligations. The bifurcation statute does not create any rights, duties, or obligations. And as Mr. Van Meter alluded to, even before the bifurcation statute, courts had broad discretion in determining whether or not they would bifurcate a case for damages and liability. So the ability to bifurcate a case has always been firmly within the discretion of the court. And it's been within the discretion of the court whether they do an apportionment first or damages. Logically, you would do liability and apportionment before damages. I think that's what's reflected in the statute. But it's been a matter of discretion. The cases, the only case, and we talked about this a bit the last time we were over here. The only reported case that we've been able to find discussing the new or citing the new bifurcation statute, Moore versus Utica Shelby Automotive, 2025 Westlaw 3124790, was presented with a request to bifurcate. And this is a Middle District of Georgia case. So it's a federal case. The party seeking bifurcation cited both the federal rule of civil procedure and the new Georgia bifurcation statute. And the federal court said, look, bifurcation is procedural. We're going to bifurcate under the federal rule of civil procedure. But I think that holding is well founded and is consistent with the fact that the bifurcation statute does not create any rights, duties, or obligations. It's a procedural matter. We also, last time we were here, mentioned the Lundy versus State case, which is 130 Georgia App 171. And we cite this on page 9 of our brief. But there, the Georgia Court of Appeals was considering a criminal statute that bifurcated the guilt and innocence phase from the punishment phase and said that that could be applied retrospectively, stating that because that bifurcation is procedural in nature and does not affect the substantive rights of a defendant who has no vested right as to the manner provided by law for holding his trial. Just as the criminal statute directing the order of events was procedural, so too is the bifurcation statute enacted in April of last year. Plaintiff argues Mr. Van Meter focused on the Martin case today. There's also a lot of briefing about the KOS case, and we addressed that on pages 10 through 11 of our brief. And I'm happy to go through that, but I'm going to focus on the Martin case instead, because I think that what the case did in Martin is important for two reasons. First, what was at issue in Martin was whether or not, I don't want to make sure I have this right, but I've got the court had erred in one of, let's see, here we go. Apologies. The court was faced with the issue of what happens when a trial court errs in its apportionment analysis. And the specific question being, what goes back? Do we go do a full retrial on the damages and liability, or can we segregate damages from liability? And it is true that the court said once liability has been established, the calculation of total damages sustained by the plaintiff is the first step. And the allocation of relative fault and award of damages, according to that allocation, is a distinct second step. I think this is a part of the quotation that Mr. Van Meter might have left out of his briefs. But it then goes on to say there's no reason these two steps cannot be segregated for purposes of trial. So Martin is better understood as saying apportionment and damages can be segregated, and they don't have to go back down for a full retrial. It's not directing a hard and fast rule that in a default case, apportionment would go first. In fact, I think implicit in the court's order that all that would go down for retrial is the part that the trial court erred on, there being apportionment, is that if the trial court had erred on damages,
It could have gone back down and just been retried on damages. In that case, apportionment would have gone first with liability, and then damages would have happened. And the second part, the second reason that I think Martin is significant is because it rejects some of the arguments that plaintiff has made regarding how her rights are affected by this purported required order in a default posture of damages going before liability are not supported by the law. And there's several ways in which they do that. First, the court notes that under the law regarding the determination of damages, the damages calculation is not affected by the identity or number of tortfeasors involved. Second, the court observed that OCGA 5112-33F1, and we note in our brief that Martin was construing an earlier version of the apportionment statute, but this language in 5112-33F1 is not affected by that. I think the big difference in that previous apportionment statute is the fact that Section B only allowed apportionment if there was more than one party, more than one defendant. And so the legislature in 2022 fixed that language. But they said that that language, which provides that the assessment of percentages of fault of non-parties shall be used only in the determination of the percentages of fault of named parties, meaning that non-parties' fault bears only on the relative fault of the named parties and therefore does not bear on the assessment of liability itself or the damages determination. So again, making the point that what you do in your damages, what you do in your apportionment, or really what you do in your apportionment does not bear on what you do in your damages. And then finally, the court stated that the general rule is that the assessment of fault among tortfeasors will in most, if not all cases, have no impact on the jury's finding of liability or on the total amount of damages to which the plaintiff's entitled. And it's that last piece that the assessment of fault has no effect on the total amount of damages to which the plaintiff is entitled, which we contend defeats plaintiff's argument that the retrospective application of the statute would affect her rights, because what the plaintiff has argued in her opening brief is that she'll get less damages if apportionment goes first, and that's simply not supported in the law. So those are the reasons we've briefed. I do want to go through a couple of the additional points that Mr. Van Meter made, and I'll try to be very quick. I'll try to be very quick here. One thing Mr. Van Meter says, there's no meaningful distinction between a default that occurs as a result of not answering and a default that occurs as a result of discovery sanction. I think that might be true for this particular bifurcation issue. There is a distinction in the law in terms of folks who have discovery sanction entered against them are not allowed to challenge the sufficiency of the pleadings. They're not allowed to go in and say that's not a well-pled allegation. I think that's the Hansford case has that language in it. We do cite it. We do cite that in our brief in the first half of this response to their trial brief.
And on a side note, I do appreciate the trial briefs. I just want to know, it was clear that both sides worked hard on those, and I was very grateful for them.
Thank you. And then I'll speak some to what the plaintiff articulated her concern being is that
will try to introduce evidence during the apportionment piece that would affect the damages phase. The defendants have no intention of doing that. And our understanding of the statute is that because we are in default, we move to apportionment of fault among all parties. And we understand that means what we're talking about in phase one is who bears responsibility for the events that occurred the night of October 28th, 2023. And that inquiry is limited to the actual events and occurrence of that night. And the Taylor versus Racetrack case has language that supports that. That would indeed be admissible and not character evident. And it's not trying to address the intangible value of Mr. Perez's life. But in Taylor versus Racetrack Petroleum, 238 Georgia App 761 at page 762, the court says the general character of parties and especially their conduct in other transactions are irrelevant matters. But then it goes on to state a party's conduct on the occasion at issue in this case may be proved only by the facts of that event and not by evidence of the party's prior acts or general character for carelessness or recklessness. All the defendants would be trying to do at the first phase is talk about the facts of the occurrence on October 28th, 2023. Nothing about Mr. Perez's educational background, standing, history with run-ins with law enforcement, propensity to deal in guns would come in at that phase. We would suggest that it would be proper that in describing the events of that night, we describe the purpose that he went onto the property. We disagree with the notion that Mr. Perez being an invitee is a well-pled factual allegation. So we would contend that Mr. Perez went onto the property that night to sell a firearm. And in the transaction with the gentleman that he went and met there specifically for the purpose of selling the firearm resulted in him being shot and killed. And as a result, the criminal assailant would bear some responsibility for what happened that evening, but so too would Mr. Perez for going onto the property for the purpose of selling that firearm. The racetrack case, another point that I want to draw from the racetrack case is they did say that certain evidence would be prejudicial. And I think that's right. If there was not bifurcation, I think to present all of the evidence that we might want to present regarding Mr. Perez that goes beyond what happened on the evening of October 28th, 2023, could be prejudicial. But as the court recognized in the racetrack case, the way to address that is through bifurcation. The court did the same thing or did a similar thing in, I want to say it's the, I'm not sure if, I'm not sure if this is one that Mr. Van Meter spoke about today. In the Leo versus Williams case, which is, I believe in Mr. Van Meter's briefing, but that's 207 Georgia App 321. And again, they're talking about certain evidence regarding a driver, and they wanted to introduce evidence that he was a reckless driver at various times. And the court said, no, we're not going to let you do that. And then the defendant said, well,
at least we should get this in for damages. And the trial court said no. And then on a appeal, the Court of Appeals noted that he had offered it only for his habitual carelessness and recklessness. Or I'm sorry, only for contributory negligence and causation, and then not sought at the trial court level to introduce that for habit or life expectancy. And so the court said, you didn't really preserve this for appeal anyways. But it went on to say that, moreover, even if the evidence was relevant to the issue of damages, the proper procedure to avoid prejudice to the plaintiff on the issue of liability is a separate trial on the issue of damages after liability has been decided. So again, this is a separate trial on the issue of damages after liability has been decided. The bifurcation statute orders things that way. It does liability and fault, including the apportionment of fault of other parties before damages. So again, point being, even if we were to say that the evidence that we want to put on about the night was prejudicial, the recognized remedy for that is to bifurcate the trials, which is exactly what the bifurcation statute calls for.
Okay. So I just want you to put your thinking cap on for a minute. I'm gonna give you an academic, and then just take a minute, and then I want y'all to give me back what this would look like in very practical terms. So I want to take us from the academic to let's fast forward a couple days. If I rule this way, what does this look like? So let's say I take a little bit of what Mr. Van Mater is asking me for, but not all of it, which is, let's say I bifurcate, fault goes first and damages go second. So remember, he's asking for the opposite. So hold on to the current state of the law. Fault goes first, damages go second. Because y'all are in default, if I were to then say, we're not going to relitigate the well-pled allegations, and as far as the fault goes, the fault would be between your clients and the third-party shooter. I'm not asking you to agree with it. I'm asking you to just tell me your thoughts. I assume you would object to the idea that there wouldn't be a percentage line for the decedent plaintiff. What would be your other concerns in that? So we can go off record and give you all a couple minutes if you want to talk it through off record. Again,
I think I can.
Okay.
I think I can start to answer this.
I just didn't want to put you on the spot.
I think I can start to answer this some. And it turns on what the well-pled allegations are, right? Again, I think the one that maybe is most instrumental to this is whether or not it's a well-pled factual allegation that he's an invitee, because that legal conclusion is based on a factual predicate that he would have been on the property for his and the defendant's dual benefit. And if that's the case, then we would likely not be able to challenge that or contest that in a way where the plaintiff shows up as someone to whom fault can be apportioned. And we cite a case in our response to their trial brief. It's the American Honda Motor case. Pull it up, and so I don't want to mangle this too bad trying to go through it on memory, but in American Honda Motor, so Honda is placed into default because of disregard for court orders, including motions in limine, and they go to make an apportionment argument. And the first thing that the court says is that look, we recognize that a defendant, even in default, is not foreclosed from making an apportionment argument. But then the court goes on to say, however, there's a yet another exception to the shall language of OCGA section 51-1233, and that is, of course, what Honda is deemed to have admitted by virtue of the striking of its answer.
Found
And-
the site.
Yeah, and then it goes through what they pled there. My point being, though, is that if it's not well pled, if it's not well pled that he's an invitee, then the reason for why he's there that night is something that would not contest any of the well pled allegations of the complaint. And so
And hold on, it's 377 Georgia app 712. Kathy's looking at me and she's more important.
I'm sorry, yeah, 377 Georgia app
I have it pulled
712
up.
2025.
All right, you can keep going.
So I think that case stands for the principle that if there's not a well pled allegation that you are directly contradicting through apportionment, and there they were, and they, we point out the level of detail in those allegations versus the lack of level of detail of the allegations in this complaint regarding whether he was an invitee or whether he had exercised ordinary care and diligence and was a completely innocent victim. But if you were to make that, if you were to get to that point, Your Honor, where you found that those were well pled allegations, and again, I'm not accepting that's true right now, but for purposes of your question, the apportionment would be. It would be then, I think, between us and the shooter. And there wouldn't be a line for the plaintiff in that regard.
And
And I think if we're not, I'm sorry, go ahead, Your Honor.
I was just protecting your right to say you're going in an academic exercise with me. Nothing you're saying is consented
This is-
to anything. I just want to make sure the record.
Yeah, thank you, Your Honor. They're purely academic exercise here. But I would say that, Your Honor, that if we're not trying to defeat the right of recovery at that point for the plaintiff, and there's a litany of cases that Mr. Van Meter has cited regarding the inability to present evidence to defeat the right of recovery. And apportionment is not defeating the right of recovery anyways. But if the plaintiff is not on the line and we're not even trying to apportion to them at that point, I would contend that we would still be able to present the evidence of what happened that night so that we could present fully and fairly the context of him being shot. Because otherwise, what we're left with is Mr. Perez went on the property the night of October 28th, 2023, and he was shot. And there's no context to why he was shot.
May I respond, Judge? Or not?
Yes, let me submit, anything else, but you. Okay.
Did that answer?
It did.
Did that answer
Oh,
your
no, it
question?
did.
Yeah.
Because that's what that's no secret. That's what I'm struggling with is my job is to give you all a clear roadmap of this is step one in our trial. This is step two in our trial. And, do we do damages first? Do we do fault first? If we do fault first, what specifically are the guardrails for y'all to attack? Because obviously if this wasn't a default case, then you'd be wide open. This is a default case, but at the same time, I want to narrow it as much as I should and as much as I'm required to, but no more. I want to make certain that you can still try your case. And that's what I'm trying, that's the thread I'm trying to pull this through. All right, anything else before I will have Mr. Van Meter answer that same question on that same academic exercise, also without waiving his objections to it.
No, I don't think I have anything. The only thing further is that if the other way to limit it, and we didn't talk about this, and maybe not directly responsive to the question, but I think the limitation, if it's found that not to be a well-pled factual allegation that he was an invitee, the limitation
would be, well, two additional limitations. One, the evidence that's presented is related to the events and occurrences the night of. And the second one is one that we haven't even spoken about, but it's in the apportionment statute. And it's in the Whitby versus Moby case, I think, is the case that's cited by plaintiff. It talks about comparative negligence. I think another effect, if we are apportioning among the plaintiff, the defendants, and the shooter, is that statute is not in play. To be and that's the subsection G of the apportionment statute on comparative negligence. There can't be a reduction, and we wouldn't be arguing for, and it's not even a reduction. There can't be a bar of recovery based on being 50+1 or more at fault, and we don't argue that, and would not argue that.
Okay, thank you. And the Whitby case, Kathy, is 150, Georgia app 575. Every time y'all cited a case, just so you know, I pull it up, I've got it on my Westlaw in front of me, and I save it.
You're better at doing that than me, because I know that's the name of the case, and I know it's in the briefing in front of me. I don't have the ability to type it in and have it. So thank you for not making me shuffle through the papers.
I got one job, get the cases. So, one job for Kathy. So, all right, Mr. Van Meter, the floor is yours.
Thank you, Judge. I think Mr. Lentz is correct, and we agree a lot more than we disagree about the state of the law. It took us a lot of briefing and research to get here, but I think Mr. Lentz is right. If the court determines that the allegations in the complaint are well pled, including the allegation that Luis was a lawful invitee, lawfully on the premise, and was a totally innocent party who exercised ordinary care and diligence. If the court makes that first threshold determination that that's sufficiently well pled, then that would bar any apportionment evidence in a phase 1 apportionment trial. Essentially, what the defense is saying is that we don't think that is well pled. And if the court agrees with us and finds that it's not well pled, then we would be allowed to tell the jury about why he was there. That's different than what the plaintiff alleged in the complaint. My position is that they can't do that because the complaint is well pled. And the Honda case that we discussed earlier actually supports that proposition, which I can discuss later because I know we're not talking now about the well pled allegations. But I think that's the first question the court has to grapple with is, what is the court going to do about the well pled allegations argument? Excuse me. If the court finds that the allegations are sufficiently well pled and that includes that Luis Perez was a lawful invitee, totally innocent, etc., it would then be constrained to find that the defendants are limited in their evidence presentation and apportionment because they can't introduce evidence that contradicts that admitted fact or tends to relitigate the issue of liability and open up the default, which they can't do. That's how I think the court should deal with that. And if the court agrees with me and makes that finding, then the evidence would be limited to the non-party assailants, the shooters. And the court had asked a question about, okay, let's say we do that. What evidence are we even allowed to talk about on the night of? Or Mr. Lentz brought that point up. I think that it would be proper for the defense to elicit testimony from the officer, perhaps, or even by stipulation, that Luis was robbed and shot. That could be additional contextual evidence as to why he was there and what was happening and why he got shot. Or something like that. I'm not saying that's what it has to be, but I think you could ask the officer, was the Luis lured there by third-party criminal assailants? Because he was. Was he robbed when he got out of the car? Because he was. Was he shot in the context of being robbed? Yes, he was. I think the defense can get those types of questions and answers to get some quote-unquote evidence following their burden of production to show the jury that the third-party criminal assailants share in responsibility for Luis's death. But they should be stopped from eliciting any evidence that would tend or have the tendency to invite the jury to conclude or that contradicts the well play allegations. So the corollary of that, I will tacitly admit and concede, Judge, that if the court agreed with the defense that the allegations about Luis were not well pled, that they would be allowed to put forth some of that evidence as long as it was admissible. Because that's the point, Judge, is that evidence of apportionment cannot contradict a default finding of liability because it operates to defeat the right of recovery and operates to assert defenses and affirmative defenses and factual defenses that are not available to them because of the default. Because that's how the default operates. I use the word sanction, but that's just the practical impact of a default judgment. You can't offer defenses, factual or otherwise, that may be true that you would otherwise have a right to because of the default.
Okay. Okay. Whew. Y'all have given me a knot. And again, it's good to be in here with attorneys such as y'all who know what you're talking about. All right. Do y'all want to discuss bifurcation anymore? Again, it's no secret. I haven't made a decision. I'm just reacting to what I'm hearing and throwing ideas out there. But you will get a decision quickly because I do know that you all need that decision to start putting together your witnesses. So when y'all leave here, I know you'll be preparing for jury selection on Thursday, but my plan is to dig in, is to clear my calendar this afternoon and tomorrow and get you all an answer ASAP so that you have firm guidelines as to what's going to happen. So do we need any additional access to the record on that? Okay.
I don't think so.
Let's just take a quick break, stretch our legs, step to the restroom. And then when we get back, we'll kind of see where we're at and what we can confidently get into without, again, having that 3-body problem where we have too many variables and we have to argue it 4 different ways. So let's all just take a break,
right.
set the restroom, come back, and then see where we can pin it. All right, we're in recess.
Thank you.
Okay. So let's go back on record. I took a few extra minutes because I really wanted to think a little bit and give you all a good lens for us to do this last part here. And what I want to do is I want to be very clear and say, I'm not issuing a ruling at this moment, but what I'm doing is giving you all an indication of kind of where I'm at to help us streamline our arguments. Because again, I don't want you all to have to say, well, if you're going to do this, then this, and if you have to do that, then that, and if you're going to do this other thing, but not this other part, then we got this fourth option. So for the sake of the rest of the afternoon, here's what I want you all to presume. Bifurcation. Fault goes first, damages goes second. For the sake of the rest of the afternoon, I want you all to presume that the allegations in the complaint are presumed to be well pled. I'm going to go back through the complaint one more time this evening after we finish. I will stay late tonight, and I'll let y'all apologize to my family. And I will make certain that whatever decision I make on it, I've done one last pass because I understand the critical importance of that piece in everybody's framework. But for the sake of this argument this afternoon, in phase one for fault, assuming that everything is pled well, that means that the decedent plaintiff will not have a percentage line on the verdict form. All right. So far, have I thrown anybody off so far? Everybody's good so far. All right. So that means that in phase one, the percentages will be Mr. Van Mater's responsibility to prove to the jury by preponderance of the evidence as to what the percentages should be between the defendants seated at the table and the third party shooter. So the apportionment is great. I'm very comfortable with the defendant's request for the apportionment between those two. I know it's not all you asked for, but, and again, this is not my ruling. This is to help us stream this in because I'm going to go back through it one more time before I give you my final official, this is what we're doing. All right, Mr. Van Mater, for the purpose of these motions in limine, so the verdict form, just to visualize it in your head, will have a line for the defendants, one or two, I don't know. We'll figure that out later. And there'll be a line for the non-party, the shooter. So the phase one verdict form will have a line for the parties, the defendants, the defendants, and there will be a line for the non-party shooter. And it'll be Mr. Van Mater's responsibility to present evidence on that to determine, for the jury to determine what that is.
Are you asking me to submit a verdict form to that effect? Presumptively?
Well, that's what we'll get to.
Okay.
But don't do it yet, because obviously I'm just trying to frame in our arguments. Because
Okay.
again, I'm going to go back one more time and look at the M5T status within the complaint. Because obviously if I pull that piece back out, that opens up phase one a little bit more for the defense. So I'm just trying to give us a good, easy framework to use for our arguments this afternoon, because I can then, if I decide to move a little bit, I'll be able to open up your arguments into wherever I may tack into, but we're at least all in the same road, heading in the same direction. We just may not agree which lane we should be in. If I've done this right, this should work okay for arguments this afternoon. Mr. Van Mater, any questions, concerns for arguments about how we're going to frame it this afternoon?
No.
Mr. Lentz?
No, I will say that you mentioned it'd be Mr. Van Meter's burden to show apportionment. I think under the law, that's actually our burden to show
Dang it,
the
yes.
apportion percentages.
I have too many plates spinning in my head. I'm so very sorry.
You know, us too. I actually had asked Javaris to make sure that was correct, but I think that was actually one of the holdings or rulings in the KOS case. But
That is correct. And thank you for that. I'm sorry. Again, y'all have given me there's a lot of different points, and I am very grateful to have great attorneys who, when I say something wrong, you look at me sideways like Kathy does and go, and that lets me know that I don't know how to do, what to do right, but I do know I did something wrong. So yes, you are correct. That is your burden. So, okay, so that'll be phase one, and then phase two will be damages. All right. With that said, does that, and without waiving any objections from either of you, does that give you all enough to be able to argue within the motions to eliminate what's next?
Yes.
All right. All right, so then, let's start with, the plaintiff's motions to eliminate, unless y'all want to do that in the opposite order. Anybody have any preference? No preference?
No.
Okay. All right, so let's start with Mr. Van Meter's motions in limine. The copy I have in front of me is from May 20th. Is that the one is that the music y'all are singing off of?
Sounds right.
Okay. All right, so that means although these are the plaintiffs, I'm not going to be hearing from Mr. Van Meter. I'll be hearing from you all, at the defense as to what your thoughts are, your concerns, your objections, your consents.
Oh. First point, we would raise on the motions in limine is, that they're filed out of time. Just to point it out, Mr. Van Meter briefed it and offered explanations, for why it was filed out of time. We've briefed, and I don't want to belabor the point, here. It's all briefed, but we've briefed why those types of explanations and, reasons aren't typically accepted by courts. So I'm not waiving, that argument, at all, but I understand that, the type of evidence that is at issue in Mr. Van Meter's, motions in limine is the type that would be ruled on at trial anyway. So it might be a purely academic exercise at any rate, but I don't mean to waive that objection, but I don't want to belabor it either.
No, you're not waiving it. And no, I'm not happy that they were late, but at the same time, I've given a lot of soul searching to it. And I think that ruling that they're late and setting them aside for contemporaneous objections, given the fact that this is also an interpreter case and will by default move slower, I believe that it's in the court's best interest, given all these issues out, for me to just take what y'all have given me and for me to give you back answers so that y'all can have the clearest roadmap as it is. So, not happy that they're late, but, at the same time, I'm not asking the defense to waive their objection to it either. So, all right, you may continue.
Okay, so there's two motions in limine that were filed that I have. There's one that's just labeled plaintiff's motion in limine. I'm going to start with that one, if it's okay. I think there's actually a fair amount of overlap between that one and the second one, which is called motion in limine to prohibit use of impermissible character evidence of deceased in the plaintiff's family. So starting with number one, prior criminal history for decedent Luis Fernando Perez. We, the defendants, would put that evidence on as part of the intangible value of life, and to show that Mr. Perez had a propensity to not go to school. He had some run-ins with the police. He was known to use drugs. And the thought process there being, if the plaintiff is going to put on intangible evidence of Mr. Perez's life, that would open the door to it. And the concerns that we talked about earlier, I want to say in the racetrack case, of those discussions, and this would be for damages only at this point, obviously, those concerns of prejudice would not be present. But because of bifurcation. And I think on that point, And I apologize. I'm trying to streamline my arguments. I'm going off script here because I'm taking out a lot of the based on the premises that you gave us. But the basis that we would argue, or one of the bases that we'd argue there is found in Judge Andrews' special concurrence in the Taylor versus Racetrack case 238, Georgia at 761, where he disagreed with the majority's conclusion that evidence that the teenager was involved in dangerous activity, taking LSD, smoking marijuana, drinking and driving. He disagreed that was irrelevant on the element of damages, but he did agree that it would have been prejudicial and that there wasn't bifurcation to protect against that prejudice. But I think this special concurrence of Judge Andrews is perhaps the best articulation that I've seen in my research of why this type of evidence is relevant to damages, and particularly so in the case of a minor who doesn't necessarily have the type of evidence that you'd have for economic damages into the future or some of the other measures that they look at. But what Judge Andrews focused on was the intangible element of the full value of life, and talked about how it's incapable of exact proof, and made the point, and I think made the point, and this is on page 287 of the opinion. But he makes the point that if the plaintiff is going to introduce evidence of the deceased's positive relationships and interests, then it follows that, as the trial court stated in this case, the plaintiffs have opened the door to evidence tending to show the negative aspects of the decedent's relationships and interests. And then he distinguished the Leo versus Williams case. So the defendant's position would be that with the threat of prejudice mitigated by bifurcation here, that if the plaintiff is going to put on evidence, and we saw their exhibits last night, but if the plaintiff is going to put on evidence showing pictures of Mr. Perez in happier times with relationships, where he was at a theme park, where he was with a church group, whatever the picture purport to show, then that would open the door for us to put on the evidence regarding his relationships in life, that his sister testified to, that he liked to do drugs, that he liked to deal with guns, that he wasn't going to school. That evidence is the same sort of evidence. It's negative to the plaintiff, obviously, but it's the same sort of evidence that the plaintiff, that we suspect and expect that the plaintiff would put on with respect to the intangible element of the value of life.
If I remember right, the racetrack case, it was a single phase trial.
Correct. That's correct, Your Honor. So it was a single phase trial, and the defendants tried to put on that character evidence, and the trial court said no, not for liability. And again, it's a single phase trial. And then on appeal, they try to make the point, well, it still would have been relevant for damages. And this is where Judge Andrews' special concurrence differed and separated from the majority. The majority said, well, it wouldn't be relevant to that. And they said, they should have, well, I'm gonna make sure I'm not mistaken.
No, I'm looking at it. What you're saying is tracking.
Okay. And they said, and I think even the majority said, who said, moreover, even if the evidence was relevant to the issue of damages, the proper procedure to avoid prejudice to the plaintiff on the issue would have been to bifurcate the trials. And then looking at head note 6 there, this is the other thing that Judge Andrews, this is the other
point that Judge Andrews is making in his special concurrence that I think is relevant here. In Head Note 6, they talk about the habitual nature of the conduct and the fact that character evidence was perhaps being used to show conformity with at the time of his death. And then they go on, and so Judge Andrews goes on to say that the focus should have been perhaps in a bifurcated setting on this intangible element. And he cites treatises there. You have it in front of you. Wilburn on the Georgia law of damages, talking about how it's tough to look at. He cites Overby and Butler, What's a Human Life Really Worth? Recovering Damages for Decedent's Non-Economic Losses in Georgia Wrongful Death Actions. And that's a law review article, 7 Georgia State University Law Review 459. But again, the takeaway there is that if the plaintiff is going to put on this type of evidence with respect to the intangible element of the value of Mr. Perez's life, then the defendants should be entitled to do the same. And the prejudice that the court was concerned with, both the majority and the special concurrence, is mitigated by bifurcation. Then, related point, and I think this argument would be foreclosed under your under the premises.
Let's call it framework.
Under your framework. Yeah, but the plaintiff argued in their brief that Ava Park was a location of choice for violent criminals. I think this is foreclosed. I would have argued that we would be able to put on evidence that Luis made the deliberate choice to go to Ava Park to engage in criminal transaction, but I think that would be foreclosed. So never mind that. Another point would be, and this does go to whether it's a habit or a hobby. Plaintiff cited Brock versus Whitingcamp 253, Georgia App 275 in her brief for the proposition that a plaintiff's hobbies can be relevant to the value of life. There's testimony from Ms. Perez that one of this is Miss Genesis Perez. There's testimony from her that one of Mr. Perez's hobbies was dealing in guns, and particularly hot or stolen guns. We would argue that if that's one of your hobbies, whether it's described as a hobby, a habit, and again, I don't think there's exact language on what all is considered as part of this intangible element or what goes into the overall value of the life. But if it's part of your life, if it's makes up the complete makeup and picture of who you are, then that is relevant to the value of your life. So that's our essentially our argument with respect to the prior criminal history argument on pages, it's not page numbers, but in section 1 of the first motion in limine it tracks and echoes what Judge Andrews stated in Taylor. The second one, the second point raised in that motion in limine is contents from the decedent's alleged Instagram pages. Again, this refers to the gun. There's a picture of Mr. Perez holding, I think it's an AR-15 and a pistol. This is similar to the point made earlier. If
by Judge Andrews and argued by defendants. But if pictures of if pictures of Mr. Perez in the good times associating with his friends and family doing other things that he enjoyed to do are relevant, then so too would be pictures of him handling guns. If those are in fact the things that he enjoyed to do, which the testimony that we've received from his sister is that he did enjoy doing those things, and that was part of what made him a person. And I don't want to be insensitive to anything here. And I recognize the duality of children, especially. They can be great and do many good things, and they can do a lot of bad things, and that's what we're always obviously fighting with against them. And so I don't want to seem insensitive on that point, but I think that point dovetails with the idea that if you're going to put on evidence of the intangible elements of the value of life, and those include pictures of him in the good times or doing things that are considered to be on the straight and narrow, then it should also include those things that society might not consider to be on the straight and narrow. The third is the effect or impact of litigation on defendant. I won't talk about this at all because we don't intend on raising any solvency or insolvency issues of our client at the trial. The taxability of the award. No intention of speaking on taxes here or hopefully ever. So.
All right, so just, here's what I wrote down, and you correct me if I wrote anything down from what you just said, because that was the last item in this packet. I wrote down as to basically 1 and 2 kind of track together. And so as to them, that there is an objection from the defense and that these things should be allowed in phase 2 as a intangible value of life evidence. I didn't catch if you all think it should just be allowed in or that it should be allowed in proportionality to Mr. Van Meter's evidence. Will you clarify that for me? Are you saying that y'all should just be able to put it in, or y'all should be able to evaluate the tone and tenor of Mr. Van Meter's evidence and then use it proportionally to respond?
Good question, Your Honor. I would argue in the first instance that we should be able to put it in. Because it is the type of, if we're talking about this sort of ethereal concept of the value of someone's life and all the elements that go into it, including this intangible element, which is, been described as incapable of proof. I think that it would be relevant for the damages for the phase 2 portion of the trial, whether that door had been opened or not. But certainly if the plaintiff opens the door, for instance, I think there's an obituary that is in the evidence packet that we received from the plaintiff that talks about his hobbies of riding dirt bikes, helping his younger family members and those things. And that's, all those things can certainly be true, but that doesn't mean that this other side of his life is not true, and it goes to the same intangible element.
Okay. And I have both of those. I have both 1 and 2 as kind of operating under that same argument. And then 3 and 4, I have you consenting to.
Yeah. Yes, Your Honor.
Okay. Perfect. Anything else before I pivot to Mr. Van Meter on this specific packet?
Well, let me just look because I don't know that I'm going to have much more to say.
Oh, great.
So that the school records would kind of fall in that same category to the extent.
Oh, yeah, Mr. Gresham reminds me, so the school records, I will come back to that at the end of the day, because like I mentioned at the outset, we've served the subpoena, there's time to comply with it was yesterday. And so we are going to ask the court for an order to compel those documents, but later. But those school records would be part of the same, sort of packet of materials that we would want to say these go to the intangible elements. And there's a case that we cited in the school record briefing. Let me find that quickly. I think it's Collins v. McPherson, 91 Georgia Ave 347, 349. It's a 1954 case. But that just talks about when valuing the life of a minor, you look at the age, life expectancy, precocity, health, mental and physical development, family circumstances, and from the experience and knowledge of human affairs on the part of the jury. And I, not to backtrack on what you just said and summarize my argument, I think that, and from the experience and knowledge of human affairs on the part of the jury in determining the value of the life of a minor would also bring in the evidence of Mr. Perez's hobbies that were less mainstream than what are in his obituary. But I do want to say that just before we go on, I don't think I've got much more.
Oh, I see what you're saying, because the impermissible character evidence would also fall under that same structure.
Same concept of what's the experience of the jury living in the world, and if you're saying because that list in that 1954 case is quite broad, but if folks in the community can say, look, if I know you're skipping school, doing drugs, selling guns, what have you, again, it doesn't make you a bad person, but it goes to that intangible element of damages, and perhaps at some point within the conscience of the jury and human experience, it might get a life expectancy as well.
Okay, I'm tracking.
Okay.
Well, take a minute, make certain that you haven't, because I've asked you to pivot. Take a minute, review stuff, talk to Mr. Gresham, see if you have anything else you want to put on the record or address before I pivot to Mr. Van Mater. And yes, we'll come back to the subpoena question.
In addition to the stuff, just agree with the witness folks in the church groups and all of that. So,
Yeah, and Mr. Gresham makes the point that the exhibit list and then witness list includes members of his church and things that we think that what he's going to put on is basically the same kind of evidence, but positive version of that evidence. It's type of character evidence, right? And I'm not using character evidence in the strictly evidentiary term of trying to use character evidence to prove conformity, but evidence of his character. If the positive evidence of his character is relevant to the intangible element of the value of life, then it seems to reason or follow that so too with the negative, and especially in a bifurcated setting where you're protected by from the prejudice of liability, the concerns of the majority in the racetrack case would be alleviated.
All right, now I see that on page 14 of the consolidated pretrial oversight.
And then, so yeah, actually looking at his second motion in limine, and this is for just for the court reporter and for the record, this is the one called motion in limine to prohibit use of impermissible character evidence of deceased and plaintiff's family. So the first motion, or the first subpart there, is that defendants seek to improperly show that Perez contributed to his own death. I think under our framework, I'm not waiving any of our arguments on that, but for purposes of today, under our framework, I'm not going to discuss. And then the other one is part B there on page 8 is defendant's evidence improperly invites the jury to consider evidence not relevant to the full measure of Perez's life and is inadmissible. This is the same, this would be the same argument. This would be the same argument that defendants made with respect to the value of life. Would add here, there's a case called Stripling, that talks about it. It's a habit case, and it talks about a woman who had the rather bad habit of drinking too much and playing in traffic, and she died that way. And the court said because because she had this habit and she died doing this, that would be relevant to her life expectancy. The defendants would take or make an argument or argue that whether it's a habit or a hobby, of Mr. Perez's of selling guns, and again, it's probably foreclosed by the framework, but I'll carry it out to the end. But because he had either the habit or the hobby of engaging in the sale of guns, and he was killed doing that, that it's relevant to his life expectancy. And I just want to, I mentioned earlier the language from the motion in Lumine about that plaintiff cited with respect to hobbies. And this is on page 10 of that brief, citing Brock versus Wiedenkamp at 253 Georgia App 275. The plaintiff argued that Georgia juries may consider the deceased person's enjoyment of daily life, their relationships with family and friends, their hobbies and interests, their role in raising children, and future milestones they'll never experience. There, Your Honor, in a bifurcated setting, especially, I would say if defendants would argue that how Mr. Perez spent his time, in any capacity, whether with his church group or whether it was with his friends doing illegal things, would be included in this statement of the law from plaintiff, that the juries may consider the deceased person's enjoyment of daily life, their relationships with family and friends, and their hobbies and interests. And on part C, so I'm on to part C. So most of part B of the second motion in limine is subsumed with the earlier argument, especially the points that Judge Andrews made. Part C, evidence of the criminal character or conduct of Perez's or plaintiff's family members is irrelevant. The argument here from plaintiffs is that I think we elicited testimony that Mr. Perez's brother is currently incarcerated. Not part of our plan to introduce that. If anything, we'd be talking about testimony from Mrs. Perez, where is it Mrs. Perez or the mom? Testimony from the mom or from Genesis Perez, saying that the brother had warned Mr. Perez not to engage in an activity that he was doing because it was dangerous. But we don't intend to affirmatively put forth evidence of the criminal character of Perez's family. There is we're running a search, just for full candor. We're running a search of criminal cases. We noticed a number of criminal cases involving Mrs. Madrigal. We're looking and running down whether any of those involved crimes of moral turpitude or fraud that we might use to impeach, but not for any sort of affirmative evidence that we plan on putting on, Your Honor.
So what I'll write for that one is consented to as to defendants' non-testifying family members. Non-testifying family members. In other words,
I think that's fair. Yeah, as consented to non-testifying family members in their criminal background. We have no intention of going into the criminal background of any non-testifying family members, and we're not sure if we do the mom yet. We've got to see what those criminal cases were about.
okay. All right, what else?
I think that's it. I think by and large, Your Honor, just for the record, that section section B of this second motion in limine is the same type of argument, the same type of evidence, the same type of concerns as what we talked about in the first motion in limine. So I want to just incorporate all those arguments from the first one that we spoke about. We're foreclosed by the framework from addressing A right now. We'll maintain whatever objections we have there. But that is the defendant's view on why the type of evidence that Mr. Van Meter is trying to exclude is relevant to the intangible element of the full value of Mr. Perez's life.
Okay. And Kathy, Stripling is 143, Georgia Ave, 742. Okay. Anything else before I pivot to Mr. Van Meter?
I think that consent may be a little bit too narrow just to the extent I want to say that his previous brother would be that. But I don't want to be.
Yeah, Mr. Gresham makes the point that we might want to mention that Mr. Perez's older brother, who warned him against some of the things he was doing, was incarcerated. The idea being that kind of warning to your little brother has more weight in effect if you're on the sort of the bad side of going down that path. So
Okay. That makes sense. Okay. Anything else?
no, you aren't.
All right, Mr. Van Meter, the floor is yours to respond.
Thank you, Judge. So I think a few cases are instructive, and I'll just try to go through the two main cases I think are the most helpful. Firstly, Judge, the Stripling case as well as the racetrack case. Well, first, let me address the Stripling case. The Stripling case stands for the proposition, if I remember correctly, that evidence in Mrs. Stripling's scenario, evidence of her habit of getting drunk and playing Frogger with traffic was admissible by the defense to show contributory negligence in the liability section of the analysis. So my position, as I briefed and as I will argue here, is that prior conduct evidence, prior character evidence is not admissible at all unless it rises to a level of habit such that it's predictive of future behavior. That's not in your framework, Judge. That wouldn't be relevant to any issues outstanding. And so it can't be admitted for that purpose. With respect to the racetrack case, the majority, which I would submit is controlling authority, says that this very type of evidence is not admissible on the question of damages. And I will also note, Judge, that the racetrack case was not a default case. This is a straight up trial. And in that case, the Georgia Supreme Court disagreed with Racetrack's argument that evidence of the decedent's alleged drug and alcohol use on other occasions was relevant to the issues of damages because that would affect his life expectancy. I will admit that just reading the Racetrack opinion, it does appear that the majority is talking about these prior instances of conduct, drug use, alcohol use, reckless behavior within the context of life expectancy. They don't specifically talk about the intangible aspects, relationships, things that made the decedent's life worth living, et cetera. But I'll just simply note that the majority opinion, which is authoritative and controlling, does hold that these isolated, non-habitual, random prior bad acts, prior character evidence are just flat out inadmissible in a damages hearing. And I think the reason for that is explained in Brock versus Weidenkamp, which is a case I cited in my briefing that reminds us the reason why these types of evidence is not admissible. These categories of evidence are not admissible, Judge, because the measure of damages is viewed from the perspective of the decedent, not those who are viewing the life of the dead person. So in Brock, Judge, I'm sure you have it. This was a car crash case where the decedent was a young mother. And in that case, the defendants wanted to introduce in a damages phase evidence of her abortions, that she had problems in her marriage, that she didn't show up to work. All that was done to show that she wasn't going to earn much. They tried to argue that her sexual practices was somehow relevant to her life expectancy because she made poor decisions. The court rejected that flatly and said it was highly speculative and far too attenuated to be relevant to the issue of damages. And it highlighted because the reason why, because let me find it briefly. Because the evaluation of the damages has to be viewed from the decedent's eyes. It's not how we all objectively evaluate her life, or how a surviving spouse or a surviving family member might evaluate their life. It's how the decedent valued their own life. And that's what I'm citing here in the brief. When it talks about what the intangible value of someone's life is, measured from the perspective of the person who died. Georgia juries may consider the deceased's enjoyment of daily life, their relationships with family and friends, their hobbies and interests, their role in raising children, and future milestones they will never experience. So, based on the holding in Brock versus Weidenkamp and Racetrack, it just seems that the type of evidence that the defense wants to introduce is just not admissible. And I'll state broadly speaking that this argument I'm giving the court is widely applicable to all the issues I've raised in both motions in limine. So it's kind of one argument for everything. So for example, I looked at the defendant's exhibits today, and there are photos of Luis Perez holding a pistol, like on an Instagram post. There are photos of Luis Perez holding, I believe, an AR-15. It like young people sometimes do when they're posing for a picture and trying to look cool or whatever. I believe they intend to elicit testimony from his sister, Genesis, that he hung around gang members and didn't go to school and dealt with quote unquote dirty guns and so forth. None of this rises to the level of habitual conduct that is so predictive of future behavior that it has any relevance at all to the value of someone's life, much less the value of his life measured from Luis's perspective. So the evidence that the plaintiffs intend to introduce from his mother and other witnesses and people from church and so forth is going to be that allowable evidence about his enjoyment of daily life, the relationships he had with his family and friends, the fact that he'll never get to raise children, the fact that he'll never get to go to college, the fact that he'll never get to own a business, the fact that he'll never get to get married or have grandchildren, go to a sporting event, and all the things that make life enjoyable. He's only 15 years old, so there's not a lot of, I'll be candid with the court, there's not a lot of evidence I intend to solicit about what his earning potential was because he was 15, wasn't working. And the court in Brock versus Weidenkamp does touch on the latitude that the plaintiff's witnesses are allowed in talking generically about some of these issues. A plaintiff in a wrongful death case is allowed to introduce some evidence, generally speaking, of a decedent's general good character, their hopes, their aspirations, the type of person they were, et cetera, and can do so without opening the door to every bad thing they've ever done. Because where does it stop? At what point does Like, where's the threshold for that? That's why we don't allow it in criminal cases. It's, there's been no expert identified by the defendants that would link any of this type of evidence to some type of life expectancy calculation. There's been no similar evidence about how any of this is relevant to his economic earnings potential. So the only way this is even remotely relevant is in the intangible section of the damages question. I simply argue that the cases that we have and the authorities say it's not admissible because it's too attenuated, not relevant. If the court is grappling with Judge Andrews's concurrence and how it might be fairly relevant, like if the plaintiff puts up all this flowery good evidence and photos and so forth, isn't it then also fair to also show the jury that he was no Boy Scout, he had problems? Then I think the proper thing to do in that context, and I'm not consenting that it would be, the proper thing to do would be to put a limiting instruction and make such evidence conditionally relevant on the plaintiff introducing that type of evidence, specifically about his hobbies and how he spent his time with friends, his hobbies, I guess you might say. I don't know exactly. But I think the plaintiffs would be allowed to elicit testimony about the other intangible categories, his enjoyment of daily life, relationship with friends and families, his hopes and future aspirations, whether he wanted to have children and grandchildren one day, whether he wanted to have a business, whether he was bright, affable, likable. I should be able to elicit testimony about those things without opening the door to his extracurricular activities that are negative. And so that's how I would do that, Judge. If the court wanted to afford the defendants that opportunity, it should make a conditional ruling of relevance based on what we submit, being carrying the burden of production and the burden of proof.
Okay. All right. Thank you. Anything else on this? Anything else on yours? Okay. All right. Anything else on this, the plaintiff's motion limiting before we pivot to the defense? Motions in limit.
Just briefly, this is pointing out, Mr. Van Meter said that the stripping case was only about contributory negligence on page, make sure.
I believed it was. I could be wrong.
Yeah.
I've got it in front of me.
Yeah, on page 743, the paragraph right before the sixth head note that begins second. In this wrongful death action, the evidence of deceased habits was relevant to consideration by the jury of the value of life. In arriving at the amount of damage, the jury should consider the age of the deceased at the time of his death, his health, his habits, the amount of money he was earning, his expectation of life, the probable loss of employment, so on and so forth, listing out the factors. And then it concludes the evidence here was relevant at the least to determination of life expectancy. I just wanted to point that out, Your Honor. And then the other thing is if by only the focus on the decedent, the value of the life to the decedent, but if the decedent liked doing the things that we put in our brief he enjoyed doing, dealing in guns, hanging out with some unsavory characters, doing drugs, that again, even whether it's viewed from the point of view of the decedent or someone else, if that's what he enjoys, that's part of what goes into the value of his life. And then I just point back to the Collins versus McPherson language, saying that in considering the value of a minor's life, you would look at the age, life expectancy, precocity, health, mental and physical development, family circumstances, and then most importantly here, and from the experience and knowledge of human affairs on the part of the jury. But nothing beyond that, Your Honor.
Okay. And I tracked all that, so we're good.
Okay.
So, all right. I appreciate y'all. All right. Well, then let's pivot over and Mr. Van Meter gets the floor as to defendant's motions in limine. I have one in front of me filed May 15th, 2026.
I have to find it, Judge. I'm looking for it.
For the motions in limine, are we staying under this, I guess, framework that, all the allegations, I mean, were sufficient and we're proceeding in that manner? Because if so, then we probably don't need to, cover the first six.
Okay, because again, the answer to that is yes. The broader answer to that is if I decide not to, then we're arguing these so that I can then pivot with them in mind of if I broaden out my initial framework that I've given you all, then I will then pull in any motions in limine that would become appropriate for you all to use. Does that work? Does that make sense?
Yeah, it makes sense. I was just, as I was, I guess, preparing what I would say to the extent I had an opportunity to, I was looking at, seven, I was looking at, motions in limine 7 and 9. And I believe that those would be impacted, and those would relate to our arguments, regarding the well-played allegations related to punitive damages. So, I mean, I guess the arguments would be a little bit more broad if punitive damages were found to not have been well pled in the complaint, which we believe strongly they have not been. So that was just something I wanted to point out at the beginning of, I guess, of this section.
Okay. All right, thank you. All right, Mr. Van Mater, floor is yours.
I'll start with the easy stuff, Judge. Motion limiting number 7, the reptile theory argument. I believe I responded in my,
Wait, I've lost you. You've lost me. Give me just a second.
sorry, sub paragraph G, page 20.
Well, can we just, I think I'm worried that I will lose track of what we've touched on and what we haven't.
You want me to go through? Start from the
Yeah,
top?
if we just start at the front and just go consent or object, and that way I can mark it.
Okay.
If we start jumping around, I will lose track.
Okay.
I appreciate the confidence you have in me, though, to keep up with it.
So starting on page 4 with the first subparagraph. Well, let me make sure that's right.
And if you'll pull that mic up just a bit so that you don't have to look up to talk to me and the mic will pick you up. I mean, that's just an accurate statement of the law unless I'm missing something. Talking about page 4.
Yeah, I'm
A.
trying to catch up. It looks like it's just a discussion of what the law is from the defendant's perspective. Okay. I take it that on page 5, subparagraph B, where it says plaintiff's causes of action and theories of recovery are not well pled, is their first motion in limine.
And we don't need to re-argue that one. We've already covered it fully, and I'm gonna look at it all again tonight before I issue my ruling. So
All right.
I'll save you argument on that one.
I do want to make sure I give the court, before you conclude, just a short blurb from a case that I think is helpful to me, unless you're telling me you don't need that.
I'm ready.
The Honda case that we talked about previously.
Yes.
I actually cited that case as well and believe it supports our position that the complaint is well pled. In that case, the plaintiffs pled that the occupant protection system of the vehicle was defective, negligent design, and not sufficiently crashworthy, and as a result, failed to adequately protect and restrain Christensen. It further pled that Christensen was properly wearing a seatbelt and properly negotiating a curve. Further, as a result of defects in design and manufacture of the CRV, seatbelt buckle and components thereof, he was ejected and killed. And then most permanently, the plaintiff pled that Christensen, the decedent, did not commit any act or omission that led to the injuries or damages claimed, and she does not bear any fault or even for the events leading to her injury, death, and damages. The court in that case said that was well pled, and I'm simply drawing a comparison to the allegations in our complaint. They are similar in terms of what they allege. It's not, doesn't flesh out every minute detail, but this is a notice pleading state, as I indicated in my most latest filing. And so that if you track the cases where complaints are considered well pled and the allegations, they are similar to the allegations in my complaint. And also, just the last point on that, I think the standard is essentially the same as stating a claim for which relief can be granted under a 12B6 scenario. So I'll move on from that, Judge, because I know we're short on time. Okay. So moving on through the motion to page 7, punitive damages award. I'm going to assume that the court will argue, or excuse me, will within the court's framework that it'll be well pled, and we will get there when we get there in terms of the phasing. Honestly, Judge, I'll state to the court, if the jury returns a favorable verdict on damages and apportionment, I will not be seeking punitives.
Okay, we'll cross that bridge when we get to it then.
Number 3, page 8, plaintiff has failed to allege facts that will support an award of damages for Mr. Perez's pain and suffering. That's just not true. He's 15 years old and was shot and killed. Again, same argument, notice pleading. The allegations are sufficiently well pled, and the inferences and evidence to go along with it in default are sufficient to establish that fact. Page 9, number 4, plaintiff has failed to allege facts and that would support a claim for negligent misrepresentation. Same argument, Judge. Same for position number 5. The defendant's contention that we failed to allege facts that would support a claim for negligent hiring, negligent retention, negligent training, or negligent supervision. That's on page 10. Our response briefs and our complaint make clear that we placed them on adequate notice about that aspect of our claim and is sufficiently well pled. And that is, and that based on the way that we pled our complaint, that is a viable claim under Georgia law. Same thing for number 6, nuisance. I think this is vitally important, Judge. Nuisance has different elements of proof than negligence and premises liability. In fact, a premise defendant can be liable to a plaintiff in nuisance irrespective of their legal status as an invitee. That's what I cited in the Bethel case almost 2 years ago when we argued the motion to open default, and which I cited in our briefs. But we cited the statutes of both public and private nuisance, and did say in our allegations that they maintain a nuisance. And that brings me to paragraph 3, defendant's motions in limine. I probably should have started here. Let's see. Motion limiting number 1, evidence to support Mr. Perez was an invitee. The court should exclude any evidence related to defendant premises liability claim that relies on a classification of Perez invitee. I think is stopped based on the court's framework. So my response is the same. Our allegations are well pled. They've been sufficiently placed on notice and they're in default. Page 16, motion limiting number 2. Evidence to support a punitive damages award. The court should exclude any evidence to put forth to demonstrate the defendant's conduct supports an award of punitive damages, including the components of allegations in paragraph 31 and 32, where we set forth our intent to seek punitive damages. Again, I would say just reserve that and cross that bridge when we get there. Again, if I receive a sufficient award on damages and apportionment, I will not be seeking punitives. Motion limit number 3, evidence to support an award of damages for Mr. Perez's pain and suffering. Same argument as I've made before on that. Motion limit number 4, I'm feeling kind of redundant, but I think I've already covered that. As well as number 5. As well as number 6. which leads me to motion limiting number 7. The reptile theory argument, or send a message, or anchoring, or conscious of the community arguments. We intend to make proper arguments under the law as instructed. So I don't object to the spirit of it, but I do want to make sure that in my closing arguments, I have the latitude and leeway to make arguments based on the evidence vigorously for my clients as to what the damages should be and why.
Okay.
Letter H, next page, motion limiting number 8, commentary or statements during voir dire suggesting the value of the case. I've got no problem with that principally. I do think plaintiffs' counsels are allowed to ask potential jurors if they have any problem awarding a money damages award or a large money damages award in general. I believe that's the case. I will follow the court's instructions on that, but I'd like to at least be allowed to ask that to make sure I don't have jurors on the panel who are principally opposed to awarding money in a situation like this. So I'd say that, like I said, I'll follow the court's instructions, but I think I'm allowed to ask at least that. Motion number 8, commentary or statements during voir dire suggesting the value of a case. I have no intention of telling the jury that it's a multi-million-dollar case or high-value case. I'm going to ask the jury to consider the evidence and follow their conscience. Motion number 9, impact on the community. I do believe I should be able to argue about the defendant's responsibility for what happened in the apportionment phase, and can foresee a scenario where that may sound a lot like impacting the community. So I will follow the court's instruction on that. I don't have a strong opinion about that. I just don't want to be hamstrung in arguing my apportionment arguments about their responsibility at fault if it incidentally bleeds over into how their negligence impacts the community at large.
All right, so I have from the reptile theory, which is G on page 20, through current, that you'll follow the guidelines of the court. In other words, you don't have a major objection one way or the other, that you'll follow the guidelines. Is that fair?
That's correct, yes.
All right, so I'm gonna mark those as consent, we'll follow guidelines.
Last one, number 10, golden rule. Acceptance to the extent I'm willing to argue damages from the perspective of the decedent. I'll just say that that's, of course, the golden rule is, of course, the law, and we intend to follow it.
All right. All right, anything else before we pivot over to Mr. Gresham?
No.
All right, Mr. Gresham, floor is yours.
Yeah, so I won't go through each and every, I guess, point that was made, because I think the briefing is pretty clear. But I mean, I do know that there's a misunderstanding as to the difference between the notice pleading and the allegations as related to the well-pled allegations that are deemed admitted in the context of a default. So what plaintiff states is incorrect, and Georgia law is very clear on that. We cite McLeod v. Costco Wholesale Corp. at 369 Georgia app 717 at footnote 8, which states, of course, whether a complaint satisfies the minimal pleading requirements of OCGA 911-8 at the motion to dismiss stage, it is a very different inquiry from whether the same complaint would entitle a plaintiff to relief in a default judgment. And you know, that case further compared 12B6 cases to default cases. Fink v. Dodd, which is another Georgia case at 286 Georgia app 366, which is a 2007 case, also illustrates this important point that even if a claim may be sufficient as a notice pleading, conclusory allegations lacking the requisite level of fact will in fact render the allegations defective in the default context. So I guess the notion that because something gets past a motion to dismiss, which it wouldn't in a default setting, in a default case, just because that happens, that you know, all the allegations are well pled and will end up being deemed admitted at the default stage. That notion is just incorrect, and I wanted to point that out.
Can I have that
to the
cite,
court.
to your second case? I typed it in wrong.
Think VDOT 286 GA APP 363 and 366 is the pin site.
I got it now. Thank you.
So yeah, I did want to point that out, and also, I guess briefly discuss the American Honda Motor Company versus Christensen case at 377 GAAPP 712, which is a 2025 case that has been discussed some today. In that case, in addition to the Contour Sierra case, there are analyses of what well-played allegations actually looks like. And I believe that for the judge, for the court to for the court to actually make its determination of whether certain allegations are well played and therefore deemed admitted and therefore deemed admitted by default, the court should look at the actual allegations and what is actually stated. So take, for example, in American Honda Motor Company, if you were to compare the allegations in this case at Penn site 720, Penn site 723 near the bottom of the page, if you compare those to the allegations in plaintiff's complaint that states that Mr. Perez was a fully innocent victim and that he met the standard for ordinary diligence, you will see that those allegations are in fact legal conclusions, and they do not actually provide any factual detail or support that is required at the default stage. For example, and you know, the court in American Honda Motor Company v. Christensen italicized some of the text to that shows, you know, the conclusory allegations, but then the rest of the text was the actual factual detail that the court looked to find that those allegations had in fact been admitted by default and were well played. Similar circumstances in Contour Sierra, where the court found that there were more factual allegations present there than, you know, can arguably be argued are present in plaintiff's complaint here. The court also found that it took into consideration in finding that the complaint was well played and the allegations were well played in Contour Sierra, that the defendants had also failed to respond to requests for admissions, and that supplemented the record, and that supplemented the court's the court's analysis to find that the allegations of the complaint were well played. So I mean, I think those are two of the main points that I would make in response to what plaintiff's counsel stated. You know, just following and respecting the court's framework, I won't go through all of the you know, all the arguments that we've already, I guess, briefed in the briefing, but I think those are the main two based on what's been stated here today.
Okay, thank you. And again, just to be very, very careful, it is important to me that none of you inadvertently waive any of your objections by participating in my framework. So I just want to make certain that it's very clear for the record that my goal is, because I'm in a little bit of not fully charted territory here, I've got a premises liability under the old rules, but the new guidelines for trial with a default, that all of your concerns remain clear on the record for the merits in case we have to address it later. So, okay. Anything else from the defense on any of Mr. Van Mater's points on y'all's motions for limine? Excuse me. Okay. Is there anything else on y'all's to-do list that I've lost track of other than the subpoena that we're about to talk about next? Because that's the only thing I have left on my to-do list that I have running in my head is the school subpoena. Was there anything else that y'all have? And then Mr. Van Mater, I'm gonna ask you the same question. All right, other than the school subpoena, is there anything else for us to discuss from y'all's to-do list today?
We don't have a lot of substantive questions, but just wanted to know like how you wanted to run voir dire.
Yes,
Yeah.
great question, and we'll circle back to that too.
No, I mean, no.
All
I
right,
just- everything I would say, I've said in my brief.
Okay. All right, well then let's talk about the school record subpoena. What exactly are you all looking for me from today on the school? Tell me exactly what you requested. I didn't dig into that as much as I did the others. I'm so sorry. I just ran out of capacity. We were here very, very late last night on the Snapchat case, and I didn't get to the full. I didn't get all the way through that one like I did everything else. I'm sorry.
Yeah.
Tell me about the school subpoena. What are you looking for? What'd you ask for, and what'd you not get?
So we haven't gotten anything. I'll be frank with the court. This was low on my priority list too, but I'm going to just summarize from our brief. So we asked for his attendance records, his disciplinary information, his transcripts, his grades, his grade point average, his academic progress, his class schedule, credit hours enrolled, earned, enrollment status. We served that subpoena back on, I think we mailed it on the 5th, was served 6th or 7th, we think, with a compliance date of the 15th. Have not, the school has not moved to quash or otherwise respond to the subpoena. The reason we're asking for it is, what we talked about earlier, in the Collins versus McPherson case, where they talk about the precocity, health, mental, and physical development, and experience of knowledge in human affairs on the part of the jury. A lot of the argument in the brief goes to how this would affect his long-term earning capacity and so on and so forth. But those are the broad categories that we're seeking. Again, we've served the subpoena, no response. This is an issue where we had reached out to Mrs. Madrigal to get the consent form for the documents that would be covered by FERPA. And please don't ask me to say what that stands for. I'm sure it's something Privacy Act. Ms. Madrigal did not want to sign the consent to give to the school to get those documents. And so we did this as a last ditch effort to get those documents prior to trial. We've subpoenaed the school resource officer to appear at trial beginning on the 22nd. So this is us, because I think what the circumstances under which the school can give that information is pursuant to a court order, or if the parents consent. So we are trying to get an order to hopefully streamline getting that information. And we wouldn't expect it to be a ton of information in whatever file they might have from Mr. Perez.
Okay. Thank you. Anything else before I pivot? All
There you
right.
go.
Floor's yours.
Your Honor, if I don't know if I have a dog in this fight, because I'm not the school and neither is Miss Madrigal. She doesn't have to consent and aid her adversaries to prove, disprove her damages. So that's kind of from her perspective. We filed our notice of objection just to state her position, so there'd be no question about it. I think that they've served the subpoena. If the school wants to quash it, they should retain private counsel and file a motion to do so. And you should do that, or deal with that as it comes, and perhaps make it, if they get the evidence and they disclose it to me, make it conditionally relevant at an appropriate time of the phasing. I'm not really sure how to respond, quite frankly, Judge.
Oh, okay. Yeah, I mean, the tightness of the timing is what's giving me pause. We're outside discovery. We're right before trial.
And discovery's closed, and this is a later
Yeah.
issue. I'm not the kind of person that's gonna, like, if a defendant want to hand me a late disclosed document, I'm used to being a prosecutor and criminal defense lawyer. That doesn't bother me personally, but I honestly don't know how it would work within the framework of the consolidated motions packet and the fact that discovery is closed. I think the exhibits we have is what we have. And
Okay.
then probably the wisest thing to do would just be to try the case on that.
And I'm not against y'all getting those things, just to say that out loud. I'm just thinking through all the different plates I'm spinning right now. So I'm just gonna say, y'all reach out to the school one more time, try to get some sort of confirmed. Yes, we're gonna give them to you, because there's no need for me to get involved if they're gonna give it to you tomorrow. So see if you can get a confirmation from the school or the school's attorney or the school system, excuse me, or the school system's attorney that they have it, they're actively working on it, they're gonna give it to you, or they're not gonna do it without further intervention of the court. And then just send an email. We already got a great email thread going that covers everything, and then just let us know. And again, I'll cross that bridge the moment I get the email on.
Thank you.
So,
Judge, just lastly, if, in a hypothetical scenario where they were produced and the defendants tendered them, I would object to them on the same basis I objected to the other evidence.
okay, that's fair. That's fair. That's a fair point. Okay. Anything else before we pivot to, and we can do this, actually, we do this part on record. Anything else before we pivot to jury selection procedure?
I don't know if it has been on the record. I have a small issue with Gwinnett County. I copied in Mr. Hope on an email. They said they'd be in touch with you guys. I'm trying to, I'm fighting to be down here on Monday and not up there. But
And who, I don't remember who your judge was on that one.
it's, Fluker's the judge. This hearing is being handled by, oh gosh,
I put you on the spot. I'm sorry about that.
it's being handled by designation by Judge Broom, I think BRUM.
Okay.
And Angela MacArthur is the case coordinator that we deal with.
Okay.
on that. So I don't know if they've reached out to you, but just perhaps put it on your guys' radar that they might be.
Yeah.
Answer is they have not reached out, not proactively reached out to this department.
Okay.
That we're probably getting on Thursday,
Okay.
that back today. This case looks like it's definitely gonna go out.
So hopefully that'll work that out for you.
Yeah, thank you.
All right. And Mr. Hope broke his solemn oath to never appear on a transcript for you. So that tells you how much he cares. So, all right. So
Apologies.
let's talk about the procedure for Thursday morning. So the way it'll work is we'll all come here. You all have access to the courtroom tomorrow. So again, if you want to come yourselves and set up or send somebody to come set up your stuff, the courtroom will be locked and secure. There is state court happening tomorrow, but it's all happening up on the second floor. It is not in this courtroom. So feel free to get set up. Each morning, what time do y'all open the front doors of the courthouse again?
So, well, to the public.
Yeah. 8 o'clock.
We're here at 7:30.
Okay, so they get here at 7:30. Courthouse doors open at 8. Not that you need to get here at 8, but that just lets you know what your freedom of movement is. So at 9 o'clock, we'll all come in here. We'll finalize the details of what we have. While we're doing that, the clerk's office will have the jurors downstairs in the basement. They will be putting them into panels of 15. As soon, and correct me if I'm doing anything wrong, Debbie. Okay, I'm just saying if I say something that's outside I'm trying to do our normal habits and patterns. So if I do something outside of our normal habits and patterns, stop me. They'll be downstairs putting our jurors into panels of 15. Our goal is to keep 3 panels. And you all want jury selection taken down, if my memory serves me correctly. Yes. And so that means they'll be over in that jury box there so that Kathy can see them. We have a plethora of, I just used a big fancy word there. We have a whole lot of microphones. And so what will happen is the bailiffs will assist us as we talk to the jurors by giving them several mics to pass around, including the 2 mics off of y'all's tables. And then y'all will use the mic on that stand there. We'll bring the jurors in. We'll have given you the list. We'll bring the first 15 in so you can mark your stuff accordingly. We haven't tried a lot of jury trials in here, just so you know, we're obviously, this was brand new. January 1, Alexander Hope built this thing from literal whole cloth. It was an abandoned, half carpeted, disgusting mess. And then he turned it into this beautiful space. But we are still working out all the habits and patterns, because this courtroom is a corner bench and it's reverse of the other courtrooms. So we'll confirm with the bailiffs before they walk in that I believe it'll be the first juror will come in and go to the back right corner and then fill in that way and then fill in to the left. And so once they're here, I'll talk to them a minute, give them their oath, give them their preliminary charge. And then you all will begin your questioning. Mr. Van Meter will go first. I expect you to ask all of your questions in one pass. I've gotten feedback from the jurors that they do not like the up and down and up and down. They want to know when you sit down that you're finished. And I thought that sounded like a reasonable thing for the jurors to ask me. And so that's the way we do it. So you're going to ask all the questions you want to ask until you have no more questions. And then you sit down, and then the defense will get to ask their questions. And they'll ask all the questions they have until they sit down. There's no insurance on this case, right? So I don't have to qualify them to anybody. But I did get in the course the consolidated pretrial order that I will be qualifying them to you all, your offices, and your clients. So, and whoever else is in there. I'm just doing that off the top of my head. When we finish with that panel, I will ask you, is there anything we need to talk about with this panel? Because again, in my head, I'm trying to create enough jurors so that we have 24 for our panel of 12. And I want at least, given the fact that we're about to go into the weekend and extra, I want at least 2 alternates, maybe even 3. Because we're about to go into a long holiday weekend and then a full week trial. So that's my goal, is that if we get to the end of the second panel and we've had nobody excused, then we may just jump in from there. If I'm doing that math right, we can at least get 2 out of there. So we'll make that decision as we go. But if we end up striking a bunch of folks for whatever reason, then we'll get the last panel in. All right. So that's just the general overview. Mr. Van Meter, any questions about procedure or anything else that?
Do we do silent strikes?
Oh, great question. So when we finish, I will excuse the jury to go wander around a little bit outside outside the courtroom. And then y'all get your 15 minutes and then we'll actually do the strikes from here. I'll have the list. We'll go on record and I'll say, our jurors that you're picking from, number 1 is this one and number 24 is this one. Who's your first strike? And then you'll just say, we strike so-and-so. And that way we've got a good record of who'd you pick and is this your jury?
So the question will not be juror 1, do you accept, do you strike? It'll be who do you strike, and whoever's left on the jury in their order.
Yeah. Why the Georgia legislature created one version for criminal cases and one version for civil cases, I don't know, but y'all don't try many criminal cases, but in criminal cases, it starts with the first juror and it says that I'm to put the first juror onto the state. And so I literally look at the state and I say, juror number 1, accept or strike. And then the state says accept or strike. And so that it's a different process. So, all right. So the answer is nope. You'll pick who you want. And then when we finish the first round and we have 12 locked in, assuming our extras, then we'll say, all right, there's the next 3, you each get 1 strike. The last one standing's it. And depending on where we're at, again, my goal is to get 2 jurors, alternates. And if y'all are just all profoundly happy with the very last juror standing and we don't have enough strikes, but y'all are like, we both love the very last juror as an alternate, then we'll stick the 3rd one on there. But there's no pressure behind that. What else you got? What other questions? Okay. Any questions at all about Thursday?
Our paralegal she's willing to come down tomorrow. She says she probably needs 5 minutes and she runs a lot of trials. Would it be possible Thursday morning between 8 and 9 a.m. for her to check things out for purposes of Monday?
That's perfectly fine.
Okay.
Yeah, Thursday morning's fine, Wednesday afternoon's fine. Just, I mean, as long as it's 8, I mean, doors are open at 8, maybe a little earlier if they want to get here earlier. So,
Thank you.
no,
I thought I remember Marty saying it was like a light count.
so, I know we have probation. I know we added a probation calendar next Thursday, the 25th, that Judge Essery is going to handle on the second floor. Let me grab my calendar here.
Make sure that.
No.
That's what I remember her telling me last week.
This isn't y'all's problem, but we've had to move with our transition between Patrick Shepard becoming Judge Shepard and us not having a fully elected solicitor in office. We've had to skip, change, cancel, and otherwise adjust more court than you can shake a stick at. It's been really difficult. So we have accountability court this Thursday at 1:30 with Judge Essery. We have, and then we have probation. Yes, probation with Judge Essery and Donna next Thursday, the 25th at 9 a.m. on the second floor. Great question. This is exactly, that's why we do this.
I remember Marty saying that last week when I was working sentence enforcement, and I was like, but maybe she meant
Yeah, I think she meant the 25th because she's creating that calendar out of whole cloth. Okay, what else you got? All right. I don't have any sort of like, oh yeah, that's right. Thank you. Judge, so remember I had the sheriff's kids camp that they were Friday for me. They're next Thursday for Judge Shepard. Sorry, this Thursday. So when we're down here picking this jury, Judge Shepard and the sheriff's kids, the next group of the sheriff's camps are going upstairs to the second floor.
Judge Shepard, you're gonna do Thursday.
This Thursday with the sheriff's kids, summer camp.
this way, it was that way.
Yeah, that's okay. So this is why we talk it through. So, yeah,
I just put up phone with him a while ago, and he said it's still on for Thursday.
that's correct, because we're closed Friday for Juneteenth. So, so again, y'all can leave all your stuff in the courtroom over the weekend. You can take it with you. You can do whatever you want, but it will be secure. It will be locked up and nobody will touch it between when you leave here Thursday and when you return on Monday.
Last person to leave this room.
Yeah. So, all right. All right. I got 4:58. Anything else? I want to make certain y'all have all the answers you need other than the answers you need me to give you, that I'm planning on staying late and giving you. All right. Well, then if that's it, I'm going to adjourn for the day.
Thank you, Judge.
Going once. All right. Court's adjourned. Thank you all.